Kalani versus Smith. Council, state your appearances.
Darryl Barker, here on behalf of the plaintiff, Joseph Kalani.
Written for defense, yes.
All right. And where are we? I received photographs, I believe, by Mr.
This case looks simple on paper. A fence, a gate, a property line. But don't be fooled. What you're about to see is a courtroom slowly boiling over as technical compliance collides with human frustration. One side claims the order was followed. The other says the spirit of the ruling was ignored. And as this judge digs in, you'll see how quickly courtroom patience runs out when arguments start slipping from legal into emotional. Direct hit purpose. A high-energy hook sets stakes without
photographs, I
spoilers.
believe, by Mr. Friedman that were sent in.
I just received these just before court. I've given a copy of these to Mr. Friedman.
Okay. Is there going to be a dispute or?
There is a dispute.
Okay. And what's the dispute?
Well, Your Honor, I will agree that the defendant technically complied with the court order, but certainly not the spirit of the court order. All right. In March 27th, they asked for additional time, 45 days, so they could re-engineer the gate. Okay. And nothing was done about re-engineering the gate. So when they took out 15 feet, we did not know there was a chain link fence on the other side. They did take out the 10 slats, but the purpose was, from the beginning of this case, was to restore access that existed for 90 years at least, or at least most of the access to the backyard. So if you leave that fence, that chain link that you see there, it defeats the reason for taking out the 20 feet that was ordered by the court.
No, it doesn't.
Well, it's right in the middle of what would be the access if that were removed.
Well,
That's his gate.
well, I know. That's the gate.
Yes, but it's within the 20 feet that was supposed to be removed. See the black mark you did take out? I
see the black mark.
that's where the fence, the 10 sections were.
Hold on. The real issue
This
was
is a critical legal distinction, and the judge is laser focused on it. Courts enforce orders based on what's written, not what one side hoped the outcome would feel like. Here, the defendant removed exactly what the order required, a specific number of fence slats. The plaintiff keeps arguing spirit of the order, but notice how the judge pushes back. The court's concern was access, not aesthetics, not convenience, and not whether someone has to turn a steering wheel slightly. This is why judges get frustrated with vague arguments. If you want something removed, it has to be requested clearly and ordered explicitly. Otherwise, compliance is measured by the letter of the law, period. Do you think courts should enforce intent, or only what's actually written in the order? Direct hit purpose. Explains compliance versus intent, educates viewers, engagement question included.
was access to the back of the property.
Unimpeded access to the backyard, yes.
Right. So the location of the privacy fence, the wooden fence, may have impeded that. I then ordered a specific amount taken out so that that was not an issue. How does that chain link fence impede?
That chain link fence was behind the 10 boards that were ordered to be removed.
I just have to say, it's not a chain link fence. It goes across Mr. Smith's driveway. It's his gate.
I know. I
They were given 45 days to re-engineer that.
Okay, so hold on. What you're really complaining about is a pole.
Yes, in the sense that if that post and the gate stays where it is, then you still have to maneuver around it. Whereas
Maneuver around it to do what?
to get into the backyard.
Oh, but
No, that's,
Look at my-
get into the backyard with what? What are you driving into the backyard?
Okay, I have to, why did we remove 20 feet if,
Because the wooden fence came up on that one side so close to the house. I mean, that pole is so far back that it doesn't, I mean, at some point, any vehicle going in at some point has to turn. And when I was looking at it and when I went out there, the turn was going to be the problem because it was almost, when the fence was up, it was almost like you were going into a tunnel. So turning, getting past Mr. Kalani's house is, hang on a quick second. Okay, turning past Mr. Kalani's home would potentially be a tight fit. This is not.
It's not a tight fit. That's a 5,000-pound SUV that's got 3 feet of room on each side.
this is a different photo that I didn't copy to Mr. Friedman, that I will gladly. It is now a gate in the middle of nowhere. Is he going to put something?
Okay,
I mean, is he now gonna put chain link?
Well,
I'm not here to decorate his property.
Okay.
I'm just saying,
Right.
what the ultimate issue was access to the back. Now, if you're telling me that as it's been laid out, there's no access to the back, then tell me that.
It's not that there's no access, Your Honor. It's that the spirit of removing, had I known when we were here on May 15th, that would still be up, I would have included in the request to have that removed. Your Honor, there is an ongoing problem with Mr. Smith and Mr. Kalani. I would like before that Mr. Kalani have be allowed to testify as to what's transpired today.
no,
Do what? I mean, transpired was, okay, look, last time we were here, everybody was complaining about how many slats. I remember very clearly, because I counted 9, supposed to be 10. Okay, so I take 10 slats out. That's been done.
I also, when we were here, talked about Mr. Smith's harassing. And today, Mr. Smith.
I don't want to go down that road, Your Honor.
I do, because this is an ongoing dispute.
It's not part of this lawsuit, and I don't want to hear about my client swearing at your client.
Well, then you can file a police report for ethnic intimidation.
Do what he wants.
He threatened to shoot my client.
Did not. In any event, Your Honor, I don't think it's.
I don't have a criminal case before me.
This is a critical legal distinction, and the judge is laser focused on it. Courts enforce orders based on what's written, not what one side hoped the outcome would feel like. Here, the defendant removed exactly what the order required, a specific number of fence slats. The plaintiff keeps arguing spirit of the order, but notice how the judge pushes back. The court's concern was access, not aesthetics, not convenience, and not whether someone has to turn a steering wheel slightly. This is why judges get frustrated with vague arguments. If you want something removed, it has to be requested clearly and ordered explicitly. Otherwise, compliance is measured by the letter of the law, period. Do you think courts should enforce intent or only what's actually written in the order?
Criminal case before me.
True.
Let me just say this. And I'll presume that Mr. Kalani would get up and say that. What would you have me do?
Remove this, or at least move this gate post back, even with where the 20-foot mark was.
Because that would stop the language or behavior.
Well, actually,
How?
to tell you the truth, Your Honor, I would like to have gone back to my original request.
I'm not going there. I've made my ruling.
I know.
Hold on. You want to bring up something where allegedly Mr. Smith is yelling at Mr. Kalani. And I'm asking a specific question. If I even say that what you said here was said, what do you want me to do? I mean, because at the end, after I hear the testimony, you're going to want me to do something that I would imagine would be directed at stopping that from happening. So if that came up, what would you have me do?
You're absolutely right. There's nothing you could say or do that would stop Mr. Smith from harassing my client. Okay, I will agree with you on that. What I had hoped to come from today is that you would order that fence post back to equal with the 20-foot mark, because that was the intent, was to open that up. Had I known that that fence, the gate was there back on March 27th, when you first ordered this, they asked for the time so we could re-engineer.
Hold on a second. When we were here the last time, I think I still have the photos. That photo was, that piece is there. I mean, there's
no new evidence here.
There's really just a post that's there.
All right.
I mean, if he closed that half of the gate, then I'm presuming what you're trying to say is that obstruction is just that post. And I don't see how that obstructs the backyard or access to the backyard.
Had I known that that post was not attached to the remaining 5 feet, I would have.
Well, Miss Barton.
I failed.
Well, Miss Barton, if I'm looking at the photos from the last time that we were here, and when I look at those photos, I can certainly tell that post is not attached to the fence.
The photos I had, I can see that half of the gate is visible.
I think that when she's talking about the spirit of this and the spirit of that, I think it is worth mentioning that earlier on, much earlier on, we talked about the fact that the removal, that going too far back was going to impact on that gate and on his privacy, and that the goal was to have the fence, the stockade fence, end at the back of his property so that he could secure that gate, which he can't right now. My contractor literally called me yesterday and said, "Why am I taking out these 5 feet? They're not in the way of anything." And I said, "You're taking them out because there's a court order for them to come out, and they need to come out." But so that's the answer to your question. My client is ordered to take that 5 feet out, so you're taking it out. Okay, I'll take the 5 feet out, but it doesn't make any difference. It's not in the way of anything. So when I went over there to see, and he took the 5 feet out, and that's when I pulled the big SUV in there, and it's like, why? It doesn't. I could turn around that vehicle 4 times in that backyard. It's irrelevant. So as far as the spirit of the order is concerned, it was satisfied with the 15 feet, and now he's got to figure out what to do with that gate. But in any event, he complied with your order of last week.
Yeah.
Agree that he complied with the aspect of taking 10 slats, but it was my understanding, and I was wrong, that gate was attached to the 5 feet. I didn't realize it was a separate post. I did not know that, Your Honor.
All right, look. If what Mr. Smith says is correct, that he's looking to secure the back part of his property with the gate that's there, the grand reality is, if Mr. Smith is correct in that, is that he's going to move that post. He's going to somehow or another do something else with that gate. But it's the gate. From very beginning, I knew the gate was there. And I knew when the last time we were here that post, that the hinge, basically, was there. And I knew, I'm looking at the photos from last time to see, just to even give some benefit of the doubt as to whether or not I would believe that that was, just based on some distortion that somehow or another, that post is somehow attached to the wood fence. I had I did not think it was attached because it's not.
Okay, I was mistaken. I thought it was attached. And that would be an error on my part, Your Honor. But if he's going to move he intends to secure and move the post, that will be fine. If he leaves it there, and then what? If he puts up additional fencing from the post?
Okay, look.
I don't know what's gonna happen.
Look.
I don't know.
I issued an order. The parties were back. We went through painstakingly what needed to be removed of that wooden fence. Mr. Smith has complied with that. And so unless, because I still have jurisdiction over it, if you really want to do it, then you file a motion, they can answer it and I'll deal with it. But there's nothing before me right now. He did exactly what I asked him to do.
I will agree with that, Your Honor.
Thank you.
All right.
Thank you.
By the end of this proceeding, the lesson is unmistakable. Court orders are enforced exactly as written, not as later imagined. In the civil dispute, the judge finds compliance and refuses to rewrite his own ruling after the fact. In the criminal portion, the court draws an even firmer line. Laughter, defiance, and pseudo-legal arguments will not derail the process. The defendant's refusal to cooperate earns a contempt sentence, not sympathy. This courtroom shows two sides of the same principle: respect for the rule of law. Whether it's property access or criminal charges, the court demands clarity, compliance, and decorum. And when those are ignored, consequences follow fast. Now, we want to hear from you. Did the judge handle this exactly right, or should there have been more flexibility? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Court calls the case, People versus Sky Jones. Oh, great. Just can't get a break.
Don't worry, Ben. Don't worry. No compelling or anything here.
Mr. Public Defender Otatella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that. Right? We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. State your name.
my name is Thomas Styron, living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding third degree?
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. Court calls the case, People versus Sky Jones. Oh, great. Just can't get a break.
Don't worry, sir. Don't worry. Sir, no compelling or anything here.
Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration, a $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
you understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styron. I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styron so that he has some discovery. And if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024. 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
a living
first of
man.
all,
I'm
watch
gonna
your
make sure you're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a CSQV trust matter involved in this? Is my social security number attached to this at all?
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
This court proceeding centers on the case of People versus